welcome to the Burr Broadcast, where we provide you with important legal updates on the latest labor and employment news. My name is Gabriell Jeffreys, and I am an associate in Burr & Forman's Birmingham office. Today, we're going to be discussing the Federal Trade Commission's proposed rule to ban non-compete clauses. On January 5th of this year, the FTC released a notice of proposed rulemaking to prohibit employers from imposing non-compete clauses on workers. This proposed rule comes roughly a year and a half after President Biden's executive order on promoting competition in the American economy. Since the launch of this initiative to promote competition, many federal agencies have been taking steps to address what they consider hindrances to competition. For example, in a previous Burr broadcast, we talked about the Consumer Financial Protection Bureau's inquiry into employer-driven debt arrangements, such as training repayment programs, and how these types of arrangements impact competition in the labor market. The FTC's new proposed rule is probably the most aggressive of the agency efforts we have seen so far, as it would effectively ban all non-competition clauses. Specifically, this proposed rule seeks to prohibit employers from entering into or attempting to enter into non-compete clauses with a worker. It would also require employers to rescind existing non-compete clauses with workers. And in addition to these requirements, it could also prohibit any other contractual provision that would require a worker to repay training costs upon separation within a specific time if the required payment is not reasonably related to the actual costs incurred by the employer. It also puts at risk other agreements that the FTC could construe as de facto non-competes. For example, any other types of restrictive covenants that could be written so broadly to function as non-competes. So you may be wondering, what does this mean for employers? Well, for now, this is merely a proposed rule and it does not go into effect yet. The FTC is taking comments on this rule through March 10th. So a final rule would not be in place for several months. And even when it does go into place, there are likely to be several legal challenges. For example, the dissenting commissioner on this proposed rule stated that this is a radical departure from hundreds of years of legal precedent and posits challenges based on 1, the FTC's lack of authority to engage in this rulemaking, 2, the major questions doctrine, and 3, the non-delegation doctrine. So there's no need for employers to immediately change their practices right now based only on the proposed rule. However, it is important that employers continue to pay close attention to this proposed rule and be aware of any updates on its status. If you would like more details on the FTC's proposed ban of non-competes, check out the Burr alert that 2 attorneys from our labor and employment group, Matthew Scully and Joe Barnello, put out last week on this topic. And as always, if you have any questions regarding these topics, please do not hesitate to reach out to Burr & Forman's Labor and Employment Group. Our team is always prepared to help you navigate these issues. Visit us today at www.burr.com.